During the recent 2025 legislative session of the Arkansas General Assembly, over 12 legislators filed nearly 25 separate bills that all had one cumulative goal: to subvert the people of Arkansas's right to self-legislate through the direct democracy process. These bills did not just target Arkansans living in Washington County or Stone County. These bills did not just target Arkansans living off Chenal Parkway or south of I-630 in Little Rock. These bills did not just target Arkansans living in the Ozark Mountains or in the Delta region. These nearly 25 separate bills targeted each and every single one of the 3 million people who call Arkansas home. Now, the good news is that only a baker's dozen, 13 of these bills were signed into law by Governor Huckabee Sanders. But the bad news is that those 13 new laws that are now in the books have effectively hog-tied each and every one of us by preventing us from living up to our state motto, the people rule, and have turned direct democracy in Arkansas into a game where the people cannot win. So today, we are here not only to officially announce the formation of a ballot questioning committee called Protect Our Rights. We are also announcing that the Protect Our Rights BQC has submitted to the Attorney General's office this morning a citizen-initiated constitutional amendment that will bring to an end the legislative tyranny that we the people are suffering under the General Assembly as it continues its onslaught to silence the voices of each and every red-blooded Arkansan. Today we will hear from 3 representatives of the now 6 organizations that have joined together to fight to save direct democracy here in Arkansas. First up will be Keisha Smith from the Arkansas Advocates for Children and Family. Next up, we will hear from Bill Kopsky from the Arkansas Public Policy Panel. And we will end our lineup with Bobby Howard from Arkansas Appleseed. After they speak, we will have those 3, as well as members of our legal team and drafting committee, take questions from the media and the public. Keisha, you're first.
Good afternoon, everyone. My name is Keisha Smith Brantley, and I am the Executive Director of Arkansas Advocates for Children and Families. We are a statewide nonprofit advocacy organization focused on administrative and legislative policies that uplift children and their families. And my role here today is to give a quick history lesson about direct democracy in Arkansas. So when we talk about direct democracy, we are talking about the initiative and the referendum process. And to be clear, that is the right that Arkansans have to propose constitutional amendments and state laws, and the rights that we have as Arkansans to review and potentially reject statutes passed by the legislature. Way back in February of 1909, over 100 years ago, our Arkansas legislature referred Amendment 10 to Arkansas voters. The purpose of Amendment 10 was to enshrine the initiative and referendum process in our state constitution. This amendment was described at the time as a provision that was necessary to our complete liberty. And as a reflection of its importance, the next year in 1910, the amendment was approved by over 69% by Arkansans. And to be clear, that process, the legislature that amended that, was a bipartisan process that was endorsed by both Republicans and Democrats at the time. When it passed, Arkansas was one of the few southern states that gave citizens this right, and we remain one of the few states that have this right, even though it is actively being challenged. Since the time that we initiated it, we have voted on a number of topics. Through our direct democracy, Arkansans have decided in 1944 that we would be a right-to-work state. But it is also how we increased the state minimum wage in 2014. Direct democracy is how we created our state ethics provisions back in 1988 and 1990. Direct Democracy created the medical marijuana program in 2016, and Direct Democracy is what led to the recreational marijuana amendment being denied in 2022. We have had measures on casinos, abortion, natural resources, and marriage, and the bottom line has been this. Whether Arkansans were for or against these measures, we have the right to vote on these matters. We have the right to determine what we wanted for our state, and the right to make that happen through going to the ballot. We are here today announcing our ballot measure because the Arkansas legislature has begun to change the rules around our direct democracy process. And with each change, the process gets more complicated. More red tape is added, and each law has made it harder for Arkansans to have a say on the things that impact us. It has made it harder for us to vote on the things that impact our children, that impact our families, and that impact our future. And so with that being said, I will pass the mic to Bill Kosky so he can describe what our ballot measure does.
Thank you, Thanks everybody who came out today. My name is Bill Kosky. I'm the director of the Arkansas Public Policy Panel. We have a 62-year history at the panel of working with Arkansans to make our communities and our state better. The right to propose ballot measures in our Constitution is a key tool for citizens to make sure that our government serves us, we the people. Ballot measures are how Arkansans make their voices heard when politicians refuse to act or act against the will of voters. One thing I love about ballot measures personally is that they are often completely nonpartisan and apolitical. They're focused on making Arkansas better instead of playing political games most of the time. And that is why we're here today, to protect and strengthen that right in our Constitution from some politicians who want to silence voters. Sadly, some politicians don't trust voters. They've said as much in committee hearings, including right here in this room. And they've stripped the right to the ballot measure process away from us. They are rigging the rules to make it nearly impossible for everyday Arkansans to propose ballot measures, to ask their fellow citizens to sign and support measures, and to even sign one themselves. We must stand up to this unprecedented power grab. Last week, we filed a motion to intervene in a lawsuit to challenge this attack on democracy in court with our partners at the ACLU of Arkansas. And today, we are proposing the Arkansas Ballot Measure Rights Amendment. The Arkansas Ballot Measure Rights Amendment is our solution to protect and strengthen our right to have a say in what happens in our communities and in our state. The Arkansas Ballot Measure Rights Amendment strengthens three fundamental citizen rights in the Constitution. First, the right of citizens to propose ballot measures. Second, the right of citizens to gather signatures on petitions. And third, the right of citizens to sign a ballot measure petition themselves. Three fundamental rights protected in the Constitution. To protect these three fundamental rights, the measure blocks legislative interference in the process and requires any changes to that process to be approved by Arkansas voters. The Arkansas Ballot Measure Rights Amendment champions due process to safeguard transparency and accountability in that process. It guarantees a fair process for Arkansans engaging in ballot measure campaigns without political meddling. Our thanks to Jennifer Stanifer and the other members of our drafting committee who are remarkable and wrote this incredibly important amendment. At the panel, we are so proud and grateful to our partners in Protect Our Rights. We have worked to defend Arkansans' right to the ballot measure process since 2019. In 2020, Arkansas voters rejected, with 57% of the vote, a legislative proposal to limit the ballot measure process. In 2022, Arkansas voters again rejected yet another attack on the ballot measure process, this time with a resounding 60% of the vote. Yet some politicians keep coming for our rights. So we're here together again, protect our rights with our fellow grassroots organizations. Protect Our Rights is a broad coalition with incredible expertise. Collectively, we represent tens of thousands of Arkansans. We have a combined, I added this up last night, we have a combined 235 years of creating a better Arkansas. It's frankly just fun and rewarding to work in partnership with these folks here and with such an incredible coalition of organizations and leaders across the state. So thanks to each and every one of you all. Our campaign is built for success. Many of the volunteer army who led other previous ballot measure campaigns, from education to the Freedom of Information Act, are committed to protecting the ballot measure process this election and helping us collect signatures again. They are amazing, remarkable volunteers, and our deepest thanks go to all of them. We conducted extensive listening sessions and polling research that shows the Arkansas Ballot Measure Rights Amendment has 80.6% support with Arkansas voters. That's a remarkable level of support. We've also raised significant early money with hundreds of thousands of dollars already committed thanks to the generosity of amazing Arkansans. We are ready to go. We hope that you will get involved in the fight with us to protect our rights. You can read our proposed amendment and about the campaign at protectourrights.org. That is protectourrights, all one word, .org. We would love your feedback on the proposal. You can also sign up to get updates, and soon you'll be able to volunteer and donate on the website. We're working. We are organizing to build a powerful coalition. My apologies if we have not reached out to your organization yet, but we would like to very soon, and we'd love to hear from you. The Arkansas Ballot Measure Rights Amendment is essential to our future as a state, and we need folks' help. Please get involved. Thanks. And with that, I'm going to turn it over to Bobby Howard, Arkansas. Thanks.
We like working with you too, Bill. We didn't even pay him to say that. Hey guys, I'm Dr. Bobby Howard, the Executive Director at Arkansas Appleseed Legal Justice Center. We do policy change work in the state of Arkansas, community organizing, and issue advocacy. To begin, I'd like to thank my colleagues who are behind me, who've been working hard together since the beginning of the year on the project of strengthening democracy in the state of Arkansas. I'd also like to thank the policymakers from both sides of the political aisle who have been steadfast allies in that work. We're here today because the Constitution of the state of Arkansas reserves for the people of Arkansas a set of legislative powers. We're all familiar with the legislative powers of the state legislature, the people who work in this building, but maybe you're less familiar with the legislative powers that are reserved for the people. It's pretty simple. Our state constitution recognizes that politicians aren't the only folks in this state that have good policy ideas, and they're not the only ones who get to vote on those good policy ideas. No offense to the policymakers that are in the room, of course. Sometimes you and I, the people, we have a good idea, and unfortunately, sometimes those good ideas are stopped in this building without even being heard. Policies that enjoy 70 to 80% of the general public's support sometimes have to be passed without the support of the legislature. So there's a constitutionally protected process by which the people can get a good idea put on the ballot for the people to vote on. In this way, our state constitution respects ordinary Arkansans like you and me. And in plain language, it holds our state government accountable to the policymaking authority of the people. Over the last decade, some politicians and special interests have worked overtime to make it impossibly difficult for the people of Arkansas to exercise their constitutionally protected legislative powers. They've set up hurdle after hurdle after hurdle after hurdle to make it harder to pass wildly popular policy ideas by a vote of the people. Policies like raising the minimum wage, medical marijuana, anti-government corruption measures, and more. We're here together, our coalition, because some politicians' efforts to undermine direct democracy in Arkansas flies in the face of the plain language of our state constitution, and it violates our state constitution's deep respect for the people of Arkansas. Our politicians should be making it easier, not harder, for the people to exercise their rights and liberties, but instead some politicians have worked to diminish the powers of the people of Arkansas while expanding their own. Today we're here for ordinary Arkansans like you and me to ensure partisan deal makers and powerful special interests aren't allowed to disrespect what our Constitution respects, which is the people of Arkansas. Our statewide coalition is proud to work across ideological divides to protect Arkansans' power, our freedom, and our constitutional direct democracy rights. The state belongs to the people, the direct democracy process belongs to the people, and we're proud to stand with the people. So thank you for being here today.
Protect Our Rights is currently made up of 6 different organizations. I want to name those organizations for the record: Arkansas Advocates for Children and Families, Arkansas Appleseed, Arkansas Citizens First Congress, Arkansas Public Policy Panel, For Our People, and the NAACP Arkansas State Conference. With that, I'd like to open it up for questions so that representatives from those organizations, as well as representatives from our legal team and our drafting committee, can answer your questions. So, who's first? No questions? Okay,
As you know, there is a similar amendment from the League of Women Voters. So is there any concern that there's some overlap here and people could be confused about the two different amendment campaigns?
Hi, thank you for that. And so our goal, we definitely know that the league has their proposal. Our goal is for those to functionally work together. We do not want there to be any confusion. We believe that they have critical components. There were things that we felt like we needed to equally add to make sure that we enshrine the rights of Arkansans in the Constitution. But we willfully, are hopeful to be able to work together in this process and talk about ways that we can make sure that both of the measures that we're working on gets passed.
I see that there's like some overlap because I think in their amendment, they have it that if the General Assembly passes a law to change the INR process, it has to go to the voters. And I think that's in your amendment as well. So, I mean, why not work with the League of Women Voters to have just one amendment?
Yeah, we're definitely open to that and welcome that opportunity.
There are some critical differences, though. We focus on the rights, the three individual rights, the right to sign, the right to collect, and the right to propose. There are important differences between the two, but Keith is absolutely right. We're hoping to work together and we'll see where the process ends. This is the beginning of the process.
Is there any other questions?
Maybe could you expand on the differences a little bit more? I know we have a great packet, thank you for that, but maybe just some specifics about what you all are hoping to try to do. I know there are a couple things right here.
Absolutely, and I'll invite Jen. That's always a good answer. Anytime you need out of a problem, you can invite Jen. But I'll just add real fast. The heart of the amendment that we filed today focuses on ensuring that the direct democracy process constitutes a set of fundamental rights in our state constitution. That's the heart of our amendment. And there are lots of reasons for that Jen Standerker can explain. I'll also add, we're all friends. It's a small state. Our organizations are all friends. We are so excited to work together in the same direction of protecting the direct democracy process in Arkansas.
So always invite the boring lawyer when you need a boring answer. So I think I want to be clear, the proposal from League of Women Voters has not been accepted by the Attorney General yet. They are still working through that process with the Attorney General. I have not reviewed their most recent version. I don't know what's in front of the Attorney General right now, so it would be inappropriate for me to speak for them or about them or tell you what's in their measure or what their negotiations or discussions are with the AG. I can talk about what we are doing here. And the instructions for me as a drafter from the beginning have always been to focus on the populist nature of what's going on here. Too often, we get sucked into this sort of process-driven, sponsor-focused argument about what the law should be and how the Constitution should work. But at the end of the day, it's about the voters. It's about what the people want. And all of these groups up here have keenly recognized that they are here to serve the people, not to speak for them. And so this measure is drafted from that focus. It is drafted from the focus of making sure voters have the rights, making sure voters know what they can and can't do. Voters know how they can directly participate in the process. Allowing the voter to come up and fix an alleged mistake with their own signature rather than ask for a sponsor to do it for them. This focus has been less about us and more about the people.
Is this ballot title written on an 8th grade reading level?
I'm sorry, I couldn't hear you.
Is this ballot title written on an 8th grade reading level? There's a lot of syllables.
So first of all, Bill just reminded me I have not introduced myself. I'm Jen Standerker. I'm the attorney working with the coalition for this. as well as other attorneys. There was a large group of us who worked to get this language right, and I expect we're going to continue working. Directly to the question about the 8th grade reading level. So for those of you who don't know, the legislature passed Act 602, which requires us to use a Flesch-Kincaid standard for readability. That's hard, right? It's hard. I've spent a lot of time working with the Flesch-Kincaid model, with that calculator, running different sort of hypotheticals through it, and learning how that calculation works. What I have found is that sometimes simplifying the language for readability actually requires you to lose substance as to what you're actually talking about. And so the challenge for me and for the drafting attorney and the drafting attorneys in this has been to weigh readability against the requirements that we notify the voters of what they're voting on. And I think there's room for both of those things, right? You'll see if you're looking at this, that this title is drafted differently than any title you've ever seen drafted before. We said, you know what, let's see what happens if we just talk to Arkansans like Arkansans and don't use legal language. Now that being said, sometimes we have to, right? There are terms like fundamental rights. Fundamental has a lot of syllables. Substantially complies. Substantially has a lot of syllables. So the analysis that we took is let's focus on readability, get it as readable as we possibly can, and stop short of deceiving the voters. If we are drafting a title that is deceptive to the voters, we'll push back on the General Assembly and Act 602. But as long as we can get it readable, we're going to do our best to get there. And no, the short answer is I don't think this version yet is that test.
Any more questions?
I was going to add one last thing. We don't think it's possible to meet both the clarity standard and the 8th grade reading level. So we tried to make it as readable as possible while meeting the standard of clarity.
Yes.
So with that being said, if you don't get an order from the court, are you going to be able to get your amendment on the ballot?
That's why we filed litigation last week. We think that we have a strong case for getting an injunctive relief against this and several other provisions. And we're just going to let our lawyers at ACLU handle that if you want to ask them specific questions. But we believe we'll get injunctive relief. If we don't, we'll have to rethink our strategy.
So, but if all the laws that the General Assembly passed this session stay in place going forward, are you going to be able to collect the signatures? You know, like, that's not like a legal question per se, but like practical one.
Sure. Our partners at for our kids went out and tried to collect signatures for a few weeks to run an experiment to see if it was doable. It is extraordinarily difficult. In particular, the legislative acts that criminalize collecting signatures, if you make an honest mistake in it, there's now potential criminal penalties. It's particularly chilling for both people collecting signatures and people being asked to sign the petitions. So again, that's why we felt this is a two-step strategy. We filed the litigation last week, we're filing the amendment this week. The both are interacting with each other, and we'll just have to see how both processes play out as we move forward. I wish I could give you the blueprint. There's a lot of other players involved, right? Other questions now? We're super excited. We appreciate all of you being here. We appreciate all of you being here. And Kwame, you want to say anything final? Get us out of here.
Again, thank you everyone for being here. We are here, as it was stated before, we are here for the people of Arkansas to help push the power level to swing into their favor instead of against their favor, which is what's been going on in the last couple of legislative sessions. We do see a path to winning this battle, and we are confident that the people of Arkansas will have their direct democracy returned to them through this effort. Thank you for coming out.